Employees typically enjoy many protections under federal and state law that aren't available to independent contractors. In Cotter versus Lyft Incorporated, the court considered whether the classification of a worker as an employee or independent contractor is generally a question of fact for the jury. Lyft Incorporated operated a mobile ride-sharing app in which passengers were matched with drivers who transport them in the driver's personal vehicles. After requesting a ride, a rider was matched with the nearest Lyft driver who could accept, deny, or ignore the request. Lyft required prospective drivers to download the app and undergo a vehicle inspection, background check, and in-person interview. Once accepted, Lyft drivers could set their own work schedules, but were required to abide by Lyft's terms of service. The terms provided a specific list of rules for drivers to follow and asserted that Lyft reserved the right to terminate drivers for any reason. Furthermore, Lyft tracked drivers' acceptance and cancellation rates as well as their customer ratings. Subpar performance on any of those metrics made a driver eligible for termination. Patrick Cotter and Alejandra Maciel were Lyft drivers in San Francisco, but Lyft terminated Cotter for using an unapproved vehicle and terminated Maciel for her below-average customer rating. Cotter and Maciel filed suit against Lyft, alleging that Lyft misclassified its drivers as independent contractors instead of as employees, and thus deprived the drivers of protections afforded to them under California law, such as minimum wage and overtime pay. The drivers and Lyft filed cross motions for summary judgment.